next session is called Can You Have an Ethical HR Practice? And it's going to be moderated by Inge Verhulst, employment partner at Kleijs & Engels, our Belgian Wiesleboris firm. So Inge started her legal career in 1994 and has developed a particular interest on discrimination and psychosocial well-being at work. She's also very well known for advising on collective labour issues and the GDPR. And she's going to be joined by three speakers who I will let her introduce herself. Hello, Inge, how are you?
I'm fine, thank you, Catherine. Nice to see you.
Yes, and you. It sounds like you're going to have a really interesting session, lots to get through. So I'm looking forward to it. Over to you.
Thank you, Catherine. Yeah, during the last 2 years, I think we've all been very much occupied by the COVID-19 pandemics, which had an enormous impact on the work floor, and which is obviously a topic in many of the sessions that we have today during this Legal HR Summit. During this session, we will speak about another trend that we see. It's a trend that already emerged before the pandemics and that we saw continuing throughout the pandemics, and is what I would call a movement of increasing awareness on a number of ethical topics. I'm thinking about the Me Too movement back in 2017 already, followed by youth climate activism, Black Lives Matter, LGBTQ plus trends, which also have an impact on the work floor. With younger generations who are joining the workforces, we see that they clearly expect HR departments to be open-minded and to have a clear policy on these topics. And with the war on talent that we see emerging again now after the pandemics, this might be an important topic for your employer branding. And this is exactly what we will be discussing during the next 50 minutes. But let me maybe start by introducing our panel. First of all, next to me to the right, we have Sonja Regenbogen, who has a fantastic name to be in a panel on diversity. For those who are Dutch speaking or not Dutch speaking, Regenbogen means rainbow. But that is, of course, not the only reason why Sonja is in the panel. Sonja is a partner at our Canadian member firm, Matthews, Dinsdale and Clark LLP. She's based in Toronto. She's very courageous because at the moment it's 6 o'clock in the morning in Toronto. So all my admiration goes to Sonja for being here. Sonja is specialized in employment law and human rights law matters, and she regularly represents Canadian employers at the International Labour Organization, or the ILO. She will be giving this session together with Matthias Storns, or she will lead the discussion with Matthias Storns. Matthias is Deputy Secretary General at the International Organization of Employers. Matthias has a very strong expertise in human rights and responsible business conduct, industrial relations and employment policies. And then the third or fourth member of the panel is Javier Alonso de Arminio, who is attorney also and senior associate at Sagardoy law firm based in Madrid. And Javier is also an associate professor in several academic institutions specialized in employment law. Our session will be divided into two parts. We will first have a discussion between Sonja and Matthias, who will discuss human rights due diligence and supply chain issues and the expected legal developments in that field. After this first part, I myself will then have a discussion with Javier on how to integrate diversity into your HR policy. And at the end of the session, we will hopefully have some time to respond some questions. But now over to the first part. It's up to Sonja and Matthias for their discussion on human rights policies.
Thank you, Inge, for that very generous introduction, and good morning or good afternoon to all of you joining us. It's wonderful to have so many of you dialing into this session. As Inge mentioned, there are numerous aspects to the concept of an ethical human resources practice. for corporations. We've heard a lot about in the last decade the concepts around corporate social responsibility, for example. And there are many dimensions, whether it be various movements, whether it be an increased focus on making sure equality principles govern the workplace, making sure that diversity and inclusion are at the top of an agenda for a corporation. So there's a whole range of topics that could fall under this subject. Today, Matthias and I are going to focus on the idea of business and responsibility for human rights. And in particular, we're going to talk about three questions. The first will be a discussion about the key legal developments with respect to human rights, due diligence and supply chain issues and the impact on companies. The second we'll briefly speak, and Matthias is the expert on this topic, is global developments in this area with respect to business and human rights. And third is opportunities and challenges in respect of human rights benchmarks. So these are the three general topics that we're going to speak to. And by way of a little bit of background, as many of you will know, the UN Guiding Principles on Business and Human Rights were endorsed by the UN Human Rights Council in a resolution in June of 2011. And the UN GPs set out the existing obligations of states to respect, protect, and fulfill human rights and fundamental freedoms, but also address the role of business enterprises to comply with applicable laws and to respect human rights, as well as language around the need for rights and obligations to be matched to appropriate and effective remedies when breached. And what we've seen in terms of the discussion evolve since 2011 is today there is very much a focus in this discussion on business and human rights on the topic of mandatory human rights due diligence. So we're going to spend some time on that today. And by way of background and introduction, human rights due diligence is a key part of the corporate social responsibility to respect human rights. And the UN Guiding Principles on Business and Human Rights spells out that to meet their responsibility to respect human rights, business enterprises should have in place a human rights due diligence process to identify, prevent, mitigate, and account for how they address their impact on human rights. And so we've seen a number of initiatives that have taken place since 2011. And we have, on a number of levels, we have both individual corporate action as well as legislative action in certain countries in the world. And the issue, though, of human rights due diligence remains a key topic in debate on business and human rights. So I think with that brief overview, Matthias, I'd be interested in your perspective on the developments with respect to business and human rights due diligence and supply chain issues in Europe. Can you tell us a little bit about that?
Thank you, Sonja, and it is a great pleasure to be here with all of you in this fascinating conference. We see a very dynamic development with regards to legislative developments on due diligence and supply chain law in Europe. Alone in the last 9 months, 3 countries have passed due diligence supply chain legislation. Switzerland, where I'm based here in Geneva, Germany, and Norway. And the European Commission will propose European legislation on supply chain and due diligence, most likely at the end of October, on 27th of October. So we see at national level as well as European level, there's much happening. What we also see, of course, is that these legislation are not aligned. When you just look at the scope, for instance, you see that in Norway, companies from 50 employees are covered. In Switzerland, 500. And the German law starts with 3,000 employees, so a company which more than 3,000 employees covered from 1st of January next year, and then 1,000 a year later. It is also when you look at the content. The European directive, of course, we don't know the proposal yet, but it's expected that it will include the supply chain liability. Whereas the German law very specifically says there is no supply chain liability. So you can see that all kinds of different concepts, scopes are coming up. There's often the feeling, from companies outside of Europe, these are European developments, what I have to do with it. The fact, of course, is that very much this legislation is impacting business outside of Europe. On the one hand, companies who are covered by these laws will really strengthen their due diligence engagement, and they will strengthen engagement with business partners around the world, being it in terms of social audit, being it in terms of expecting that these companies do their own due diligence, being it also that they might de-invest from certain markets because it's too risky to stay in a country when you are covered by these laws. So it's a huge risk actually for business outside of Europe that people will not source anymore from your region because of it is just too risky. And then the other point where businesses covered by this or where is impacted by this legislation is, of course, if they themselves have employees in these countries, right? In Germany, for instance, if a US company, is a Canadian company or whatever has more than 1,000 employees in Germany, it will be covered as well as it is a normal Germany company. So the impact of these laws, of this legislation, will be much bigger than just in Europe.
Thank you, Matthias. These are really important points because I do think that there is a perspective amongst certain sectors that this really is a European development. These are European issues. And I think you've highlighted both the developments in Europe, but also why it matters outside of Europe. And picking up on that, what I think is also interesting is the North American context. We have seen the development of legislation in the state of California. In 2012, the California Transparency in Supply Chain Act was introduced. And that is sort of a standalone piece of legislation right now in the US, but very much imposes human rights, due diligence, respect for human rights, anti-child labor obligations onto corporations that are subject to its application. Also, largely to date, Canada has taken a policy approach to corporate human rights due diligence in the promotion, but not yet the adoption of legislation. However, in October of 2020, a new bill was introduced in the Canadian Senate. If passed, Bill 216 would enact the Modern Slavery Act. So this would be the first legislation of its kind in Canada, which would impose obligations on large entities to report annually on the measures taken to prevent and reduce the risk of forced labor or child labor used at any step in the production of goods in Canada or elsewhere by any entity, or the production of goods imported into Canada. And so while it's my view that there's very little chance that this act will be enacted because of who it's sponsored by, it doesn't seem to have a lot of support at this moment, but you can see with this type of legislation being introduced, there is a movement to move towards a legislative response to create law around these issues in North America, in particular, Canada as well. Matthias, could you tell us a little bit about some of the global developments on the business and human rights stage?
Sure. I mean, I would like to focus on 2 or 3 developments. The first one is the negotiation on the binding treaty on business and human rights. In 2014, the Human Rights Council voted in favor of a proposal to establish an intergovernmental working group on business and human rights to develop this treaty. We are at the moment negotiating the 3rd revised draft treaty. In fact, the negotiations will take place on 25th of October, so in 3-4 weeks from here in Geneva. And the content so far is very concerning. What we see there is supply chain liability throughout the complete supply chain. We see liability for natural and legal person, which means that, for instance, a director, human rights manager in a company would be personally liable for whatever happens deep down in the supply chain in tier 4, tier 5, down at the farm level. We see a very broad extraterritorial jurisdiction, which covered everywhere where a company has regular business. Everywhere where a company has regular business, it can be brought to court. And for many multinational companies, this, of course, is nearly universal jurisdiction. And what is more concerning, the victim or the plaintiff can choose the applicable law. So you can easily imagine a situation where a worker from Bangladesh who came to the Middle East to build a hotel, have their adverse human rights impact, would like to bring the company who is building the hotel chain to court in the country where this hotel has whatever kind of operations, which is for many hotels around the world. Let's say he chooses the US, and then he says, and I want then the applicable law should be the German law or the Bangladeshi law. So it's completely absurd, so to say. So that is with regard to the treaty. How long will this process go? No one knows, actually. We see a dropping number of states engaging in this treaty process, which is on the sign that, you know, they're losing perhaps interest. But it will be seen in this October meeting whether there is any chance to find agreement on some basic provisions. So far, even countries who are supporting the treaty cannot agree on basic stuff, like, for instance, the scope, right? Whether the treaty only should focus on multinational companies or on all companies, whether state-owned enterprises should be exempted, and so on and so forth. Another development we see as the International Labour Organization is a negotiation about, do we need a binding convention on global supply chains? That is what trade unions want, and that is their agenda coming into these negotiations. Where do we stay there? The International Labour Organization, the office, will present a report now in November in which they look at in how far ILO normative and non-normative work is fit in order to address decent work in global supply chains. This report then will be given to a tripartite working group, 8 employers, 8 workers, 16 governments, to develop recommendations for the ILO in order to strengthen their work in global supply chain, in not only in global supply chain, actually in supply chain generally. So we need to see what comes out of it, but that is also development which is going on at the moment. And if I have 2 seconds more, I just would mention a third one, which is the work of the UN Working Group on Business and Human Rights on a roadmap for the better uptake of the UN guiding principles. You have mentioned, Sonia, it's the 10th anniversary. They were endorsed in 2011. And now the UN Working Group is looking at possibilities how to strengthen the uptake. The roadmap will be presented in a soft launch at the end of October, in a hard launch 1st of December. And hopefully it will be a roadmap which focuses on all 3 pillars. The first pillar, responsibility of governments to protect human rights, the responsibility of companies to respect human rights, and then to have remedies. Thank you.
Thank you. You're more than entitled to take a few more seconds, because that's very informative, and you really are the expert on this topic. So that's a very helpful overview. I know you've condensed a lot of developments and information into a bite size. When you were speaking, I was thinking about a recent Canadian case in which Eritrean workers claimed that they were conscripted through the Eritrean military regime into forced labor, where they were required to work at the premises of a Canadian mining company. And they claimed that they were subjected to violent, degrading treatment. This particular group of workers then brought a legal action in the province of British Columbia in Canada against the company, and seeking damages for breaches of international law prohibitions against forced labor and crimes against humanity. And they also sought damages for breaches of Canadian law, including negligence, unlawful confinement, battery, and a number of other legal arguments were advanced. So both arguing international law and arguing that Canadian domestic law applied, despite the fact that they were nationals of a different country and working in a different country. The company brought a motion to try to get the whole matter dismissed on a basis of a variety of arguments. And this went all the way up to the Supreme Court, which found that customary international law is automatically adopted into Canada's domestic law without the need for legislative action, and that the claims of the Eritrean workers would now proceed on the merits within the court system in Canada. So this is a very interesting development because for the most part, this is very different than our American friends and the approaches their courts have taken to these kind of allegations of breaches and the extraterritorial application of domestic law, as well as obviously the application of international law. So this is certainly a space for both, in my view, European companies as well as North American companies, really global companies. Anywhere you operate, this is an important issue for you to be aware of. Perhaps, Matthias, I could ask for your thoughts on whether there's case law like this that has happened in Europe or any other countries that you think is helpful to know about?
Absolutely, and that are also new developments. We saw the famous KIK case at the Oberlandesgericht Dortmund. KIK is a garment company, a retailer, and they were faced with the fact that the supplier in Pakistan burned down, horrible, many people dead. The company directly showed itself responsible by providing remedy to the victims directly through an NGO as well as through the ILO, a huge amount of money. But still, then there was brought this claim at the court in Germany against the company. And of course, the court then had to judge according to Pakistani law, which is, of course, for a German judge quite challenging. So what happens then is that the court went to look for an expert. It took a long of time. Finally, they found someone in the UK. Of course, experts in Pakistani law, they needed another long time to go through the documents. Everything needed to be translated. So finally, he came with a judgment from his side that according to his understanding, the case needs to be dismissed because of it ran out of time, right? According to Pakistani law. And that was then the end of the court rule. But it just shows how challenging it is actually if you want to bring a case forward in a different court system, and this has then to judge according to foreign law, right? It comes with all kinds of difficulties, and I really believe there is no replacement in extraterritorial jurisdiction for good working local judicial systems, right? If we want to give broad masses of people access to remedy, we cannot trust on the laws in Toronto or in Dortmund or wherever. We need systems in Pakistan, we need systems around the world where these cases can be handled. Thank you.
That's a really helpful perspective. Thank you, Matthias. So I would just like to thank you for joining us today. Your expertise in this area really is unparalleled, and I would like to thank the International Organization of Employers, of which you are a lead executive with, for all of their work in this space. And I think it's important to note that the work of the International Organization of Employers does transmit the voice of global business within a number of multilateral systems, including the ILO, but also has a prime seat at the table in all of these negotiations with respect to business and human rights. So thank you, Matthias, for making time in your busy schedule for joining us. And with that, Inga, I would turn the panel back over to your attention. Thank you.
Thank you for having me.
Inga, you're on mute.
Apologies. Yeah, I was thanking you, Sonia and Matthias, for your very interesting discussion on human rights and human rights policies. Now, we will discuss, Javier and myself, one of the most important human rights, I think, the one, the equality principle that you already mentioned as well. And as I mentioned in the beginning of the session, we have seen, among others, due to the Black Lives Matter movement, we see an increasing interest in companies to become more diverse and more inclusive. And we get many questions of clients in different countries within Jus Laboris on how to introduce a diversity policy. And I think the importance of a diversity policy can be illustrated with a case that we had here in Belgium during last summer during the Olympic Games. The case was on a well-known journalist, sports journalist, who is employed by the Flemish public broadcast company, and who was commenting on an event on Facebook. Now, at a certain moment when the event was finished, he thought, the journalist was under the impression that the live channel was switched off. And at that time, he started a conversation with one of his colleagues. And during that conversation, he started to make inappropriate jokes about the female Belgian basketball team. He started to compare them with, or giving comments on their appearance, saying that they looked like male because they are so tall. And he also made inappropriate jokes about their sexual orientation or their alleged sexual orientation. And because this was sent out live, it was heard by a great or a massive audience, and there has been a wave of public indignation following that event. And obviously, the journalist has also been first suspended and then sanctioned. Now, I think this shows that if companies do not adopt this type of behavior, do not have preventive measures in place to prevent this type of behavior, that can have very important consequences, not only for their reputations, but could also give rise to legal claims for bullying or harassment. Now, what can employers do in this case? Obviously, with this case in the Belgian press, there has been a public debate ongoing. And one of the solutions is always you have to increase diversity. You have to have a more diverse journalist team. But will that be sufficient? That's, of course, the questions. I think what we need is also a change in mentality. And how can we become that, or how can we obtain that change in mentality? I think two things are important. First of all, to have a policy in place that will explain the vision of the company and the values that you stand for. And next to that, raise awareness on not only inclusion and integrity and the importance of that, but also how values and norms can be very different in different generations and in different cultures. Now, when companies want to introduce a diversity policy, we see that one of the first questions that always comes to their mind is how can we monitor or how can we measure how diverse our workforce is? And we've seen that I think in the North Americas, it's not really a problem to start measuring or monitoring the diversity of a workforce, whereas here in Central Europe, there are issues with the new privacy laws. Now, Javier, if we look at the situation in Spain, did you also receive this type of questions by Spanish employers? And what would you advise them when they ask you, can we monitor the diversity of our workforce? What would be your response to that?
Thank you, Inga. It is a new trend. We are getting more and more questions on how to monitor diversity, mainly from Spanish subsidiaries of American or UK multinationals, but also for big Spanish companies that have a big presence outside Spain. The question is quite obvious. How can you measure whether your diversity policy is working, on whether all the investment you're doing in diversity awareness is really working if you can't monitor the diversity, and that's the main question they're doing. Traditionally, lawyers would tend to say, forget about diversity monitoring, because we used to have a quite restrictive vision of diversity. The main concern was not to enter into discrimination, and there was one easy way to avoid or to challenge any discrimination claim in court, which was to say, I didn't know that this employee had this specific condition, and therefore I could have not discriminated him on that basis. But companies have changed the state of mind and the pressure or notion to know whether monitoring can be done. There is no specific employment law or discrimination law that prescribes diversity monitoring in Spain. However, the way we have introduced the GDPR in Spain makes it very complicated to monitor diversity, basically because we have stated that consent is not a valid ground for collecting or processing data related to gender identity, sexual orientation, ideology, beliefs, religion, or trade union membership. Therefore, there is a very, very strict limitation to the possibility to process that data, because the other arguments or the other legal grounds under the GDPR that could permit processing this information do not have a link in Spain, because we don't have any legislation actively promoting diversity on those grounds. So we just have legislation obliging to hire certain quotas of disabled employees, and legislation obliging to promote equal treatment between men and women. Therefore, we do have grounds to treat that information, disability, and of course gender, but there is no such legal ground to treat the other diversity grounds, and therefore it's very complicated. And as you know, the fines for breaching GDPR are very, very extreme. This would be considered a very serious sanction under Spanish law, and therefore a serious infringement, and therefore sanctions can be of up to 20 million or a 4% of the turnover. That's clearly an issue. We tend to advise to try to make this processing anonymous, but you know, this is always an issue depending especially on the size of the company and how many employees you have in a certain category, because it will be very easy to track down who has a specific background or the like. And it is good to know we are not alone. And as you know, Inga, we've done our research in 20 different jurisdictions in which Jus Laboris is present. I think we prepared a slide so you can see this map. This is available in our website. You see the link below. You'll have access to that. And we basically did a research on 25 different jurisdictions and did the same question: is it diversity permitted in your country, and which are the risk that you are facing in case you monitor diversity without having a legal ground to do so? And we found that around 65% of these jurisdictions had a very restrictive legislation on diversity, minority, or just directly prohibit this monitoring. There are two different groups of companies on this within the companies that do not permit monetary diversity. There are some countries in which is directly prohibited by anti-discrimination laws. So, for example, you have the case of Croatia, Czech Republic, or Finland, in which discrimination law proscribes or prohibits making any question to employees of matters that are unrelated to their job. So, to avoid discrimination, you cannot ask anything that is not directly related to the job, and therefore you cannot ask anything that is related to diversity. For the rest of the countries, the situation is very similar to Spain. The limitation comes mainly from GDPR regulation and data protection regulation. And either consent is not permitted as a valid ground to treat this type of information, or even if it's permitted, the general construction by the data protection agency is that an employee cannot give a free consent, that he is bounded by an employment relationship, he needs the job, and therefore he's going to give the consent, but this is not going to be a free consent, and therefore it's not valid. And therefore, I think the majority of the jurisdictions we've seen have a similar situation as those in Spain. Obviously, there's a tradition in Anglo-Saxon countries to promote diversity, and therefore you can see that the US, Australia, or the UK permit diversity monitoring. It's also permitted in other countries of the world because the legislation and GDPR permits consent, and they're not so strict on the construction of consent. That could be the case, for example, in Russia, Romania, or the Slovak Republic, where they consider that consent can be freely given within an employment relationship and therefore accept monitoring. And then you'll see we have some amber countries. Those are countries in which either diversity monitoring is permitted under certain circumstances and respecting certain procedures, or the risk for not complying with the law is not significantly high. And talking about risk, you can face from monetary sanctions, as you will face in Spain, from criminal liabilities, seems to be the case in France, which you can be judged to up to, you can be sentenced to up to 5 years imprisonment for undue diversity monitoring. Where we are going, is there a trend changing this current state of affairs or not? We seem there's not a big trend to change the laws at the moment. Okay. Only 12% of the jurisdictions we've researched seem to have some changes in the pipeline, some new legislation. It seems Denmark is going to implement some changes to promote certain monitoring for gender identity in order to promote diversity in that sense. And the Netherlands has some interesting developments also, but that's mainly it. So it's really a hot topic, but law doesn't help. And we tend to manage that, I think, in all jurisdictions, same way, try to do an anonymous monitoring, see if that works. Otherwise, you have to stick to promote diversity through policies and awareness and hope things work, but without many information on whether they are actually working or not.
Well, thank you, Javier, for that very useful overview. And employers now know where to go when they want to find out about the restrictions in different countries. And for Belgium, you have seen we are in red as well, for the same reasons as in Spain, exactly the same reasons, the GDPR, and there is no legal exception in Belgium. And this has also been confirmed by our Belgian Data Protection Authority. But Javier, maybe let's move on to another hot topic, the gender pay gap. It's not a new topic at all because it has been there for, I think, a decade. And I've been looking into some statistics, and I found out that the gender pay gap at this moment in time is stands at 14% on average in the European Union, meaning that female employees will on average earn 40% less per hour than their male colleagues. And I also did some investigations on the North Americas, on the situation over there, and it's very comparable. Female employees in the USA will earn 84% of their male colleagues. And what is striking is that this situation has gone on for 10 or 15 years without really significant improvements. And the reasons are divided. It's not all about active discrimination by employer. I think the main reasons are threefold. The first reason is that women are overrepresented in low-paying sectors such as care and education, where you will see that male employees will proportionally much better represented in better paid sectors such as technology and science and engineering. Second reason is work-life balance. We will see that traditionally, and I think it's still the case today, women will spend fewer hours on paid work than men. And then the third reason is the so-called glass ceiling. That's obviously still there. Women are much less presented in management functions. On average, only 10% of the CEOs in the European Union are female. This being said, apparently there are large differences between the different countries, and also in the United States you will see that there are differences within the different states. Now, what is interesting in the European Union is that in March of this year, so very recently, a proposal directive has been introduced, only a proposal, so it's not a final text yet, to ensure equal pay for equal work, which is, of course, one of the main principles of the Treaty of Rome in 1957. And the key takeaways of this directive or proposal of directive are and I give you 4 key takeaways. The first one is that prior to employment, during the recruitment process, there will be an obligation for employers to give full and transparent information to job seekers on the pay range of a job vacancy, and they will not be allowed anymore to ask about pay history. So this will, I think, lead to a very important consequence for recruitment, because I think now, at least in Belgium, employers are still very much negotiating on salary levels, and this would be excluded with this new prohibition. A second takeaway is that during the employment, workers will have the right to request information on the individual pay level they have, and also compare it with the average pay level of other workers who are doing the same work or work of an equal value. So again, this will be this will have important consequences for HR departments. Thirdly, employers with 250 employees or more will have to publish regularly information on the pay gap between female and male workers in their organizations. And lastly, as is the case usually, and which is very common with European directives, there will be effective penalties for non-compliant organizations, and there will be possibility for compensation. Those who suffer pay discrimination will be given the possibility to have full recovery of back pay and related bonuses. And so all these measures may seem very far-reaching for HR departments, although some of them are not really new. The pay gap reporting obligation is an obligation which already exists in a lot of EU countries, not all of them. I think about 10 countries in the EU already have this type of obligation in place for several years already. At least in Belgium, this is the case. Employers have to report every 2 years on the gender pay gap. What we do see is that, and that's maybe different to other European countries, that there's not a lot response to that of trade unions. So companies will report that pay gap, but there's not a lot of that's being done with it. Now, we've had one interesting case in Belgium before the courts, and we've seen a similar case in Germany, where this reported pay gap led to a presumption of gender discrimination, leading to a situation where the employer would have to prove and provide evidence that there was no gender discrimination. In the Belgian case, the employer succeeded to prove that there was no discrimination made. But in the German case, they are still waiting for the final outcome. Of course, again, this is an important trend that we see, and that would also be confirmed in the new proposed transparency pay directive. At this stage, we do not know yet whether the proposed directive will be in place or when it will be in place, and then it would be a directive, so it will still have to be implemented into national law. But it's obviously a very interesting development that we will follow up with within Jus Laboris. Now, if in the meantime some of you would be interested to know whether there is a gender pay gap reporting obligation in your country or in some of the other countries, there's also, as we have for diversity and monitoring, we also have a very interesting map on the Jus Laboris website that you can see here, and you can scroll again. It's the same mechanism as for the diversity and inclusion monitoring map. You can scroll over the different countries and you will find where there is a gender pay gap reporting obligation. Now, Javier, I understood that in Spain, if we would scroll over Spain, we would find that there is also this obligation. But I understood that it's quite a new obligation in Spain. Is that correct? Can you elaborate a bit more on that?
Yeah, it is. That's absolutely correct. We had a lot of developments on equal treatment, and within the last couple of years, basically from the moment the new government entered into force, they started to do a lot of changes on equal treatment. And regarding pay gap, they include two developments. First one is the obligation to do a report on salaries paid, and second one is the obligation to do an audit on gender pay gap. So basically, the first one, the reporting on gender pay gap is mandatory for every company in Spain, and that's already applicable for every company in Spain. And it's an obligation to register all the remuneration paid to employees. Then this means not only salary items, but also salary in kind, variable, and non-salary compensation. So, for example, you'll have to include whether employees are receiving compensation for the school of the kids, or they're receiving compensation for traveling or whatever. So everything, every payment done to the employees has to be included. And basically, you have to disaggregate that by gender and per professional category. And this has to be done every year, so it's not biannual like in Belgium. This is a yearly obligation. And the transparency to be given to this report depends on whether a company has or not a workers' representative elected. So if you do have a works council, or you have a working delegate elected in your company, you'll have to provide them with the full information, including their register. If you do not, every employee has the right to know which are the gaps per professional category and per salary concept. So every employee in the company can ask for this information, and what he will receive is which is the gap in each category and each salary concept. For example, if women are paid at 25% less of fixed salary in this category, or if the problem is variable salary, that's the information they will receive. This obligation differs a bit if you have more than 50 employees. If you have 50 or more employees in the company, there's an additional obligation, which is to explain which is the rationale behind the gap. So you have to provide certain explanation on why there is a gap of 25%. And this, on top of this, we have what we call the audit, the salary audit report. And this is limited for companies that are obliged to do an equal treatment plan, which due to these legal developments is any company with 50 employees or more. And the audit plan, if the report evidences that there's a salary gap, the aim of the audit plan is to detect which are the reasons for this gender pay gap, and prepare a planning with defined actions and timings to solve the matter. The tricky thing is, the relevant thing is, you have to negotiate this with the trade unions. So it's no longer something you do internally to feel comfortable with what have you done. You need to check with either with the works council if you have elected works council, and if you're not, you have to knock the door of the trade unions and say, I need to comply with the law. I need to negotiate with you the salary audit, and this is a big change for Spanish companies that had no workers representative. They feel a bit concerned of the idea to have to negotiate with the trade unions and show them which are the salaries of the like. But I think that's the most relevant changes in Spain.
Well, thank you. That's very interesting, and I have the impression that what you have in Spain goes much further than what we have in Belgium, and is already more in line with what the proposed directive would mean for companies. I think we are at the end of the session. I just going to check again, but I don't think we had any questions for us. I think, Javier, that we agreed that we would, as a final conclusion, would just mention an interesting case in each of our countries. And maybe I will start for Belgium. We've had a very interesting case last year, and I don't know if we also have that in other countries, where we had a female job applicant who was badly hearing and who was refused in a selection procedure. And the court found that she was discriminated based on her disability, because the employer had mentioned that there were issues with her not hearing well, but that she was at the same time also discriminated based on gender, not only during the process, but also in the decision for hiring. So what happened is that this lady got 3 compensations for discriminations, and in Belgium, the fixed damages are 6 months of salary. So she was granted 18 months of salary for not being hired. The company went into appeal, and it was reduced to 2 discriminations, disability and gender discrimination. But still, I think this is a very interesting development where you can have a case of multiple discrimination. I don't know if you had the same in Spain.
It's really interesting. In Spain, what we saw in the last few years is that people are starting to, especially companies, and to take it serious to solve equal treatment problems. We did have laws from the year 2008, but at that moment, no one really take care about the obligation to implement an equal treatment plan. I think the economic downturn helped a lot on that, because people were more concerned on restructuring than other things. But what is interesting is that even we have gone through COVID-19 and on all the problems that meant, people and companies have actually taken it really serious to comply with all new laws. And I think this is a clear change of mindset in Spain and also in the labor inspection. And we have a lot of additional changes in the law. For example, we have mandatory equal paternity and maternity leave for employees, and all this is obviously reflected in case law. We're starting to have a lot of judgments on whether you actually negotiated equal treatment plan or negotiating was not valid because you didn't call the trade unions and the like. And one interesting piece of case law we recently found is a case in which an employee filed a null and void dismissal claim saying she was discriminated based on gender because she was dismissed after getting married. So basically, the court decided she was actually discriminated because even men and women both can get married. If a woman getting married usually implies she might get pregnant, and usually it's a woman who take care of the children and ask for reductions on working times and the like. So this was a very interesting development in the sense that some companies, fortunately not many of them, tend to try to advance the moment of discrimination to try to avoid. And they just considered this was a clear case of discrimination based on gender, which clearly amplifies the scope.
Yeah. Thank you, Javier, for this interesting case law, and I think it shows that not only in Spain but in all our countries, this is really a developing trend where we have much more attention for discrimination case law. Hence, the importance of having a diversity policy in place. I would also like to thank again Sonia and Matthias for their contribution. And I am giving the floor back with this to Catherine. Thank you all, and have a good continuation of your Legal HR Summit.
Thank you, Inga and Sonia and Javier and Matthias. A fascinating and wide-ranging discussion with a lot to take in. It's great to see legislative developments in the area of supply chain due diligence, but also to note the challenges and inconsistencies that were brought up too. With diversity monitoring, also interesting to note the differences in each country's position and whether it's acceptable and the impact of the GDPR on this. In Asia Pacific, where I'm based, data privacy legislation is not generally as strict as the GDPR, other than in China, as you may have noted, and therefore monitoring can take place in many countries, but there's still limitations here too. And what can I say on gender pay gap? I really truly hope that one day we'll no longer have to be talking about this because equity would have been achieved, but all the reports seem to think this is going to take centuries. But anyway, it's good that legislation is coming in on gender pay reporting, but hopefully this will lead to some real meaningful change. Whether it be speedy or not is a different matter. And thank you all for the interesting cases at the end there.